Hello, Dr. Moody and fellow classmates for EDL 850. This is my Module 12 Tort Liability presentation, and I'm Rick Hall. Tort liability definition. Tort liability is the legal obligation to a victim as a result of a civil wrong or injury. A tort liability arises because of a combination of directly violating a person's rights and the transgression of a public obligation causing damage or private wrongdoings. My first school tort case that I reviewed is called Frame versus Como. Casey Frame was an 8th grade student, and Dr. Barry Como was a science teacher at Opelousas Catholic School. Como was acting as a substitute teacher for Frame's last period class by request of the original teacher. Como administered a spelling test to the students, but during the course of the test, many students became disruptive. At that point, Como asked them to leave, and the offending students complied. Shortly thereafter, Casey Frame spoke aloud and during the test, and Como asked him to leave the classroom twice before approaching Frame's desk. Frame responded by slowly standing up to face Como. Simultaneously, Como grabbed Frame by the arm to assist him out of the classroom. The combined actions threw Frame off balance and caused him to stumble backwards down the aisle, where he hit the podium and eventually came to halt against the blackboard. Frame was then removed from the classroom. Frame's mother sued the school for negligence. In my reading, I found this definition of negligence. Although teacher liability extends to intentional torts, such as assault and battery, most legal actions against teachers are brought under the theory of negligence. Negligence is often categorized as the failure to exercise the standard care that a reasonably prudent person would have exercised in a similar situation. And, all of my examples, this phrase, reasonably prudent person, keeps coming up over and over again. In the classroom context, it says that negligence can be broken down into 4 elements. Does the teacher owe a duty to the student? Did the teacher breach that duty? Was the teacher's failure to fulfill her duty or his duty the cause of the student's injury? And the last question was, did an injury occur? Well, in this case, the court found that the teacher was not negligent and had provided plenty of directions for the student to follow, and there was no injury to the student. So in Frame versus Como, the court found in favor of the teacher, Mr. Como. In this instance, reactive measures in USD 218 where I live, if this occurred here, I'm not really sure if there would be any reactive measures. We had an instance a couple weeks ago where a fight broke out during an activity. A teacher grabbed a student and wrestled him to the ground. It was to prevent further altercations between the students. So I think we have pretty good measures in place here at USD 218. Proactive measures for prevention. I'm 6'4", 250 pounds, and one thing that I made a decision a long time ago, regardless of the situation, I would never put hands on a student except to protect another student and to protect myself. But this situation that we talked about in Frame versus Como, when a student refuses to follow an order, it's easier to push it up the chain than to get physical with a student. USD 218 has a professional code of ethics, and one of those things listed in the USD 218 ethics is that unless there's a danger of bodily harm for the teacher or the student, teachers are to keep their hands to themselves and not restrain students. So I think it's very clear. I've been in situations where I worked in first and second graders in special ed and had to restrain students, but we did it to protect them from injuring themselves and others. So USD 218 has very clear guidelines about physical contact with students between teachers, so I think they do a good job of being proactive. The next school tort case, example number 2, is Flanagan versus Canton. Brendan Flanagan was a 5th grade student at Canton Middle School. Flanagan was participating in a gym class when on the particular day the teacher noticed that students were getting rowdy and out of control. Generally, the last 4 to 5 minutes of the physical education class was set aside to allow students to change. As a result, the teacher stopped class early and lectured the students on the importance of listening to directions during the activity. After the lecture, Flanagan and his peers were dismissed and sent to the locker room to change before their next class. While the students were in the locker room, one student pushed Flanagan from behind and caused him to fall into a locker and bench. Due to the incident, Flanagan sustained several personal injuries that ultimately resulted in emergency splenectomy. Although the physical education teacher normally accompanied the youngsters to the locker room, he remained in the gymnasium that day to speak with another student. The court actually found in favor of Flanagan for this and found the school and the teacher negligent for failing to supervise the students properly. I think I'd have to agree with that. I've actually taught physical education classes and know that you have to supervise the kids all the time, especially in the locker room, or things will happen. So this finding wasn't surprising to me based on what happened to this young man. Reactive measures in USD 218, if this occurred here. I would say if this occurred here, we already have rules in place that students need to be supervised at all times. I know there are situations where our weight room is on the 2nd floor of our gym building and the locker rooms are on the 1st floor. So I don't think that our most of our classes, our strength coaches actually go down in the locker room with kids. So this actually could happen here at USD 218. If that did happen, if somebody was injured, they would just say, you have to be in the locker room with them all the time. So that would be a reactive measure. I think proactive, I think you need to supervise the kids at all times, at all places, and make sure that they keep their hands off each other. Make it clear to them that in situations where there might be fighting or shoving or pushing, that they will be held accountable for those actions. Again, the professional ethics benefits for this. Constant supervision protects the students, and it protects the school district and the teachers from any kind of injuries. But for me, I think the most important thing would be just we don't want anybody injured. And the locker room is a great place to do it when there's not a teacher around. So professional ethics, monitoring your students all the time, making sure they're supervised is going to cut down on these kind of instances. School tort case number 3 is Mosley versus Portland Public School District number 1A. On November 13th, 1987, 15-year-old Chrisetta Mosley was attending classes at Jefferson High School. During her lunch hour, she became involved in a fight with another student, Wanda Griffin. Griffin produced a box-cutting knife and stabbed Mosley several times. Although there were security personnel on campus, none were in the hallway when the altercation occurred. Mosley was stabbed in the face and chest and suffered permanent scarring as a result. Now, the court found that the Portland School District prevailed on this issue of discretionary immunity, and second on the plaintiff's failure to adequately support her claim of negligence under the theory that security personnel failed to break up the fight in time to avoid serious injury to plaintiff. Reactive measures, if this happened here, I would see if a situation like this happened in USD 218, they would have police personnel in the hallways. They would most likely, this would be so far out of the norm for our school district and for our school that most likely there would be a police presence every day to deter these kind of actions. I don't know if they would start searching people at the door, having a knife like she used in that instance. It is really easy to hide unless you have metal detectors. Those are the kind of things that the 9/11 bombers got through security onto the airplane. So Reactive, I don't know. Proactive measures for prevention of this type of incidents. There had to be some situation that led up to the fact that this young lady felt she had to stab this other young lady. I don't think, what can you do? You can't get in the mind of kids. Being proactive, again, about teaching them about anger management. I honestly don't know how you could be proactive to prevent something like that. Professional ethics, benefits, anger management training for students. If you're really gonna go down the deep end, you put in metal detectors. But like I said, this kind of incident would be so foreign to USD 218. I can't imagine what you could do professionally to prevent anything like that. School tort case number 4, Hopkins versus Spring Independent School District. Celeste Adeline Hopkins, a student at the elementary school in the Spring Independent School District, suffers from cerebral palsy. Her mother, Celeste Eugenia Hopkins, alleges that while the students were left unsupervised, Celeste Adeline was pushed into a stack of chairs and sustained a head injury. She had mild convulsions, developed cold sweats, and became dazed and incoherent. The teacher did not call for help or send her to the school nurse. Later, an occupational therapist noticed her condition and took her to the nurse, who told Celeste Adeline to stay at school. The nurse did not contact her mother, an employee of 618 of the school, and did not contact her doctors, although the school knew the names of the doctors. At the end of the school day, Celeste Adeline rode on the school bus to the daycare center. She suffered severe convulsions while on the bus. The bus driver contacted a supervisor, requesting a school nurse be provided at the next stop, but none was provided. The driver was told to take her to the daycare center, where she finally received medical treatment. There are so many things that are wrong with this one. First of all, I would think that a person with cerebral palsy should be monitored or have an aide with her at all times. And it amazes me that a school nurse and people who are in charge of this young lady's health in the school district would make such ridiculous decisions. In the decision, it was written like this: Mrs. Hopkins contends that the school personnel shall be liable for their negligent acts, which resulted in serious bodily injury to her students. No professional employee of any school district within the state shall be personally liable for any act incident to or within the scope of the duties of his position of employment in which the act involves the exercise of judgment or discretion on the part of employee. Now that's Texas Educational Code 21.912. So the court actually found in support of Spring Independent School District because the decisions that were made were based on the judgments of the school personnel. I mean, to me, it doesn't seem fair. I would think, again, a person with cerebral palsy and they start having those kind of things, I would go the extra mile. Seems like you would be prudent in going the extra mile to make sure that she's well taken care of or checked upon. So even though the court found in support of the school district in this case, I'm not really sure that was the best decision. I think the people of the school district need to be a little bit more diligent in monitoring their ADA personnel, ADA students, ADA individuals. Reactive measures, if this happened in USD 218, I guarantee you if that happened here, there would be some training done, there would be some policy changes, there would be clarifications of policy, and there would be absolutely some professional training for students and or teachers and staff to make sure that these ADA individuals are better taken care of and better watched over. I think proactive measures, prevention. Our district, we have 12 ADA individuals in our high school alone, And I think the district does a very good job making sure that they're monitored at all times and with support personnel and policies in place to make sure in case of anything that happens. We have a young lady who's laid up in a large wheelchair, and she's had strokes and a couple different things, and she has a full-time aide, and everybody makes sure that she's taken care of at all times. So again, at USD 218, we're very small, and I think there's huge advantages for that for ADA individuals. We have professional ethics benefits here. The policy, the school board policy, and the school board has very strict guidelines, very strict processes to make sure whenever there's an injury or a possible injury that those things are reported, that they're documented and taken care of appropriately. School tort case number 5 is Homan versus Manhattan Beach School District. In the summer of 1974, plaintiff Michael Homan, a 10-year-old boy, attended summer school at the Foster A. Begg School in defendant school district. On July 16th, Michael arrived at school to attend classes, but before the end of scheduled classes, he left the school premises. At a public intersection, a motorcycle struck Michael and he was seriously injured. A few hours after the accident, plaintiff Mary Ann Homan, Michael's mother, saw him in the hospital and suffered emotional and physical injuries. Plaintiffs alleged that the accident and resulting injuries were proximately caused by the school district's negligent supervision. In the appeal for this case, the 10th Court of Appeals affirmed the judgment. The court pointed out that under the governing New Mexico laws in California, although school authorities do not have responsibility for protective supervision at all places and under all circumstances, school authorities do have the duty to exercise ordinary care in protecting and supervising the students while they are on school grounds. So the judge in the first case found in favor of Homan, and it went to a higher court, and they also found in favor of Homan. So even though the child was injured off school grounds, the school district was negligent in not making sure that he stayed on school grounds when he was supposed to. Reactive measures here at USD 218, if something like that happened here, there would be a change in policy. There would be increased supervision. A summer school, it happened during a summer school, so I would think that they would group the summer school students together, make sure there were more people supervising them, take more head counts, those kind of things. Proactive measures for prevention for this kind of thing would be, again, increase supervision, increase the times that the students were checked on, and make sure they understand the consequences for leaving the school grounds. Professional ethics and benefits, we are responsible as teachers. We are responsible for the safety of these students when they're under our care and supervision. So again, I've said that 218 has a very clear guideline, very clear policies and rules, that the expectations for teachers to guard the safety of their students. It's not a Reader's Digest version, but it is very clear, and I would personally feel very disappointed if any students that I was supervising ever got harmed in this manner. To sum up, we look at these 5 cases and what could have prevented these incidents, and to me it's supervision, supervision, supervision. I look back, and the first case was basically just keeping your hands off of students, and then it's constant supervision, supervision in the hallways. We have a rule here that in between the classes, the teachers have to go stand out in the hallways. So when the bell rings for to change classes, I go stand in the hallway. So everywhere in the hallway, there's a teacher standing, and it does cut back on foolishness. The cerebral palsy girl, and also this young man who went off campus, it's supervision. Just like the boy that was in the locker room that got injured, it's supervision. You've got to supervise these kids at all times. So it's our responsibility to make sure that they're safe. It's our responsibility to look out of them. And if we don't, we become negligent. So that's my presentation for Module 12, EDL 850. Thank you.